Hello everyone, welcome to MOOC course on Criminal Justice Administration. I am Neeraj, Assistant Professor at National Law University, Delhi, and I am here before you to present a module on Remand Procedure. So let us begin with the learning objective of this module. The very first learning objective of this module is to highlight the statutory norm that governs the field of remand under the Code of Criminal Procedure. Second, to present a comprehensive understanding of the procedural issues involved in the matter of remand. Third, to highlight the remand procedure under various special laws. And lastly, to understand the role of judicial pronouncements that impact the procedure of remand. So let us begin with the introduction of the module. Detention in police custody is generally discouraged under the law. Both the Constitution and the Code of Criminal Procedure do not allow detention in police custody for more than 24 hours. Same is highlighted in Article 22 subclause 2 and Section 57 respectively. Where detention for a longer period is required, the same must be authorized by an independent authority, and in this very case it can be from a magistrate. Such authority is vested on the magistrate under Section 167 of the Code. So where the police officer is of the opinion that for the purpose of investigation the arrested person requires to be detained for a longer period of time, he must bring him before the magistrate for further detention. When the arrested person is brought before the magistrate for the first time, the magistrate must look into the legality of arrest, and it is not required that in all cases the magistrate must allow remand in custody of police. But if the magistrate finds that there is no case for detention for a longer period, he must release the person on bail. But where he is satisfied that yes, a further detention is needed for the smooth investigation or interrogation, he may allow the same by invoking Section 167 of the Code. Other than Section 167 of the Code, there are two other sections as well which deal with remand. One being Section 209 subclause B and another Section 309 subclause 2. Now let us discuss what is the basic difference between these three sections. Where Section 167 deals with remand at the stage of investigation, Section 209 subclause B and 309 subclause 2 deals with remand at a later stage of inquiry and trial. Therefore, if we categorize these three sections into two categories, Section 167 can be termed as precognizance remand provision, whereas Section 209B and 309 subclause 2 can be termed as postcognizance remand provisions. So friends, Section 167 remand procedure will be discussed in great detail in this module, but we should not miss to highlight the relevance and importance of Section 209 and 309 as well. Therefore, this very slide will highlight the relevance and importance and the object of Section 209 and 309 respectively. So remand under Section 209, it deals with remand of an accused person during the committal of a case. Thus, where the investigating agency has submitted the charge sheet within the stipulated time and the accused person is not released on bail, and if it appears to the magistrate that the offence is exclusively triable by a court of sessions, the accused can be remanded to judicial custody under Section 209 subclause B until such commitment has been made. The magistrate is empowered under Section 209B to remand the accused during and until the conclusion of trial as well. Now remand under Section 309. Section 309 subclause 2 deals with remand in cases of postponement or adjournment of an inquiry or trial after the cognizance taken or trial has commenced. The power of a court to direct remand of an accused either in terms of Section 167(2) or Section 309(2) thereof will depend on the stages of trial. As I have mentioned, whereas Section 167(2) would be attracted at precognizance stage, Section 309(2) would be attracted only after cognizance has been taken. Section 309(2) merely enables the court to remand the accused if in custody. It neither empowers the court to remand the accused if he is on bail, nor it enables the court to cancel the bail. So this makes the situation clear and the difference as well between section 209 and 309. Now we proceed with section 167 of the code, and in this section we will discuss not only the types of remand or period of remand, but also the authorities who are empowered to give remand and how remand of females to be given, and lastly the procedural requirement for police and magistrate to be met under section 167. Now let us begin with the procedure for remand. The investigating officer is required to move an application for remand before the magistrate, satisfying the requirement that he needs that person for investigation purposes. Section 167 is supplementary to section 57 of the code, which requires fulfillment of two preconditions. First, that the investigation cannot be completed within the 24 hours time as stipulated in section 57, and second, that their accusation are well founded against the accused person. Section 167 requires the police officer to send the arrestee before the nearest judicial magistrate along with the case diary. It is pertinent to mention here the case diary is of great importance, because it is through case diary the magistrate comes to know about the accusation against the person as well as the evidence collected so far by the police, and it helps the magistrate to decide whether or not remand the person to further custody. Now, period of remand. Originally the old code had 15 days period for remand, but later it was found to be insufficient in cases of serious crimes. The legislature has extended the remand period from 15 to 60 days when the new code was enacted in 1973. But it was also felt that 60 days time period is not sufficient for an effective investigation in serious crimes. Therefore, in 1978 the code was amended and a period of 90 days was introduced for offences which were more serious. Presently, section 167 prescribes two time limit of remand for various offences. A 90 days period is prescribed for offences punishable with death, life imprisonment or imprisonment for 10 years or more, whereas for all other offences a 60 days time period is prescribed by the code. Such enhanced time limit serves two purposes. First, it gives sufficient time for the investigating agency to complete the investigation in more effective manner, and secondly, it confers right on the arrested person to be released after the expiry of the said period of 60 or 90 days. So students, so far what we have discussed, let me summarize that. So we have discussed the types of remand, which is either in police custody or judicial custody, and secondly we have also seen the period of remand, which initially was of 15 days, but how the period has been enhanced to 60 and then 90 days by the amendment in 1978. With this, we will move on to second segment of this lecture, where we will discuss the authorities who are empowered under section 167 to order remand, and we will also see the impact of filing of charge sheet on the right of the accused person to be released on bail. So students, as I have told you that there are certain authorities who are empowered to give remand under section 167, let me tell you a very important phrase used in 167, and that is the nearest judicial magistrate. Now let us discuss the relevance and importance of this very term. Section 167 confers authority or power to give remand on every magistrate, be it judicial or executive, regardless of him being the jurisdiction to try that case. The only difference is with regard to the time period, whereas the judicial magistrate can remand a person for 15 days, the executive magistrate has authority to remand that person for 7 days only. So now let us see what is the difference between the power of a judicial magistrate and that of an executive magistrate. So the judicial magistrate to whom the accused person is transmitted may authorize the detention of the accused person in such custody as he thinks fit for the first 15 days. If the judicial magistrate to whom the accused person is transmitted is not empowered to try the case or committed for trial considers detention beyond 15 days unnecessary, he may order the accused to be forwarded to a judicial magistrate empowered to try that case. In case of executive magistrate, if the accused person is produced before an executive magistrate, he may authorize detention in such custody as he thinks fit for a term not exceeding 7 days. Before the expiry of the said period, the executive magistrate is required to transmit the copy of the record along with the entries in the case diary to the nearest judicial magistrate. Where the accused person is forwarded to judicial magistrate, he may authorize further detention for the remaining period of first 15 days excluding 1 week or the actual period of detention ordered by the executive magistrate. So as we have discussed, the maximum period of detention in section 167 is decided by the quantum of punishment prescribed for that offence. So where the investigation pertains to any case punishable with death, life imprisonment or imprisonment for a term exceeding 10 years, the period is 90 days, and for all other offences it is 60 days. It is also to be seen here that the very order of remand is not a mechanical one or to be given in a routine manner. The magistrate must apply his mind to the case and should grant or give remand only when it is very important or necessary for the purpose of smooth investigation in the case. Now students, let us discuss the nature of custody in 167. Section 167 talks about two types of custodies, one being the police custody and another being the judicial custody. One of the doubts with regard to section 167 custody which has come many a times before the court is whether police custody can be given for more than 15 days or not. Such an issue has come in a series of cases, but it was the case of CBI versus Anupam J. Kulkarni which has set the issue at rest and settled the matter once for all. In this very case, the Supreme Court has stated that the custody in first 15 days can be altered from judicial to police and vice versa. But after the first 15 days is over, the only custody which can be allowed is judicial custody. The bench in Anupam J. Kulkarni case has mainly focused on two different expressions used in section 167. One, from time to time, and second, in such custody. By reading from time to time, the court has opined that there may be more than one order ordering custody, and it can also be a multiple order in the same custody, could be judicial or police one, or there can be several orders switching custody from judicial to police or police to judicial one. And after the expiry of first 15 days, the only custody which is allowed under the law is that of judicial custody, and no case police custody is allowed or granted under section 167. Another important issue pertaining to remand procedure is that of production of accused person before the court. You will be surprised to know that under the old law such requirement was not there, and remand could have been given even if the accused person is not brought before the court. But under the code of 1973, this anomaly was removed, and for every remand the accused person must be brought before the court, and after satisfying that the accused is physically present before the court, the magistrate must allow remand. This is a requirement in case of a police custody, but in case of judicial custody the law seems to be a bit relaxed, and such presence can be secured through video linkage. So therefore, in case of judicial custody, the accused person need not be physically brought before the court, whereas for police custody, each and every time the accused person must be brought before the court. The object of such requirement is that the accused person can bring before the court any torture which he might have faced in the police custody, or he can also make any other representation before the court which he would have otherwise not provided with if he would not have been brought before the court. To ensure that the accused person was brought before the magistrate is required to take signature of the accused on the remand order. What if accused person refuses to give his signature? Explanation 2 to section 167 deals with such problems. It provides that where the accused person refuses to give his signature, the magistrate may issue a certificate stating that the accused was produced physically in his court for remand. Another peculiar situation which may arise in the matter of remand is where the accused is involved in more than one case. So where the accused is involved in more than one case, or where the accused has committed more than one offence in the same transaction, whether the police custody can be taken for all the offences or the entire transaction will be treated as one, and only one police custody of maximum 15 days can be allowed in such a case. In this regard, the Supreme Court in Anupam J. Kulkarni case has stated that there cannot be any detention in the police custody after the expiry of first 15 days, even in a case where some more serious offences committed by the accused person in the same transaction comes to light at a later stage. But this bar is not applicable if the same accused person is involved in a different case arising out of a different transaction. If he is in judicial custody with regard to earlier case, he can formally be arrested regarding his involvement in a different case and made him to join the investigation in that case. Another important point with regard to remand procedure is the computation of period of custody. Whether the period of custody is to be calculated or computed from the date of arrest, or it is from the date of first production of the accused person before the magistrate. In this respect, the case of Chhaganti Satnarayan is very important. Now we will see what the court has held in the case of Chhaganti Satnarayan. The initial period of custody of an arrested person till he is produced before a magistrate is neither referable to or nor in pursuance of an order of remand passed by a magistrate. In fact, the power of remand given to a magistrate becomes exercisable only after an accused person is produced before him in terms of subsection 2 to section 167. If the initial order of remand is to be made with reference to the date of arrest, then the order will have retrospective coverage for the period of custody prior to the production of the accused person before the magistrate. That is, the period of 24 hours custody which a police officer is entitled to have under section 57 besides the time taken for the journey. Such a construction will not only be in discord with the terms of section 57 but will also be at variance with the terms of section 167. So finally, the court has concluded that a magistrate can remand a person for 15 days as a whole or at different periods from the date of first production of the accused person before it. The first period of 24 hours belongs to police, and the order passed by magistrate under 167 will not have a retrospective effect to cover the period of first 24 hours. So students, in this segment we have discussed that how the period of remand in section 167 is to be computed, as well as what happens when the accused is brought before the magistrate, that how his authorization of his custody is to be given. So what we have seen that in case of police custody, the accused must be brought physically before the court, whereas in case of judicial custody, it can be through video linkage. We have also seen and discussed that what happens or how the remand is to be given in cases where the accused is involved in more than one case. So with this, I conclude the second segment of this module, and now we will proceed to the third segment, which is the final segment of this module. Now let us discuss the consequences of non-filing of charge sheet within the stipulated time under section 167. As I have mentioned you that section 167 prescribes 60 and 90 days for filing of charge sheet. At the same time, section 167 confers a right on the accused person that where the investigating agency fails to submit the charge sheet, within this stipulated time, he is subject to release on bail. Proviso to section 167(2) was inserted to prevent the unnecessary prolonged custody pending investigation. It states that as soon as the 60 or 90 days period is over and no charge sheet is filed, the accused person shall be released on bail. Every person released on bail under section 167 will be deemed to be released under chapter 33 of the code. The order for release on bail under section 167 is not on merit, but it is due to the default of the investigating agency. Section 167 does not allow automatic release of the accused person on the default of the investigating agency. It is contingent on the action taken by the accused person. The very term is prepared and does furnish bail as appeared in section 167 is clear that it requires the accused person to move a bail application to be released on bail under 167. Now what happens when a bail is granted under section 167 and a charge sheet is filed subsequently? Whether the accused person's liberty is extinguished, can he be taken back in custody, or he can still be at large? Such an issue has come up before the Supreme Court in the case of Bashir versus State of Haryana as early as in 1977. In this very case, the Supreme Court has stated that the power of court to cancel a bail which is preserved under section 437 subclause 5 is equally applicable to a person released on bail under section 167(2) of the code. The cancellation of bail can only be on the grounds known to law, such as tampering with the evidence or his being at large is not in the interest of justice, and the fact that charge sheet is filed subsequently can by itself be no ground for cancellation of bail. Subsequently, in the case of Raghbir Singh versus State of Bihar, the Supreme Court has reiterated the view taken in Bashir's case. So, this sets the matter at rest and makes it quite clear that once the person is released or enlarged on bail for the default of the investigating agency, a subsequent filing of charge sheet will not defeat the right of the accused person, and he will remain enlarged on bail unless the grounds known to law are the ones which are moved by the prosecution for cancellation of bail. Therefore, merely filing of charge sheet is not the ground for cancellation of bail and so granted under section 167. Remand under special laws. There are many special laws which has a replica of provision of section 167 but with different time periods. In these special laws, the remand to police custody is extended from 15 to 30 days, and whereas the entire remand period is extended to 180 days, or in some cases it goes up to 1 year. In this regard, the case of CBI versus Sanjay Dutt is of great importance. This was the case in which the court has coined the term if not already availed of, and subsequently in case of Uday Mohan Acharya, this term has given its full meaning and read in favor of the accused person. Now in Sanjay Dutt case, the court has opined that the indefeasible right accruing in favor of the accused person is enforceable so long the charge sheet is not filed. Once the charge sheet is filed, such a right is extinguished. Therefore, it is very important to ascertain when we can say that the accused has availed of his right, whether it is the time or date or day when he has filed the application for bail before the court, or it is the day when the matter is heard by the court, or it is the day when finally he is released on bail. Subsequent cases will explore this issue more, and the case of Uday Mohan Acharya in particular will set this issue at rest. So in the case of State of MP versus Rustam, the Supreme Court has opined that even if the accused person has moved a bail application, but if the charge sheet is filed subsequently, his right will be extinguished, and it is not the day on which the bail application is filed, but the day on which he is actually released. But in the case of Uday Mohan Acharya versus State of Maharashtra, a 3-judge bench of Supreme Court has overruled the observation made in Rustam case. So in Uday Mohan Acharya case, the bench has observed that if the meaning of the expression "if already not availed of" as explained in Rustam case is accepted, it would cause great injustice to the accused and would defeat the very purpose of the proviso to section 167 subclause 2 of the code. If the expression is interpreted to mean that the accused must factually be released on bail, then in a given case the magistrate may intentionally postpone the hearing to provide the prosecution more time to file the charge sheet. Therefore, the accused is said to avail of his indefeasible right the moment he files an application for being released on bail and offers to abide by the terms and conditions of bail, even though the court has not considered the said application and has not indicated the terms and conditions of bail, and the accused has not furnished the same. The indefeasible right will not be extinguished even in cases where the accused has moved to higher courts challenging the erroneous order passed by the magistrate. So in such cases, if the charge sheet is filed meanwhile before the magistrate, such right of the accused will not be extinguished so long as the matter is not disposed of by the higher court. Now let us discuss the power of the magistrate to defer the hearing on bail application so filed in his court. It has been observed quite often that when a bail application is moved on the default of the investigating agency by the accused person, the magistrate do not take up that instantly and postpone the hearing for next day. It also vows some time for the prosecution to file the charge sheet. Such a tactic is highly criticized by the Supreme Court in more than one cases. In the case of Neeraj Yadav versus Union of India, the Supreme Court has criticized the magistracy for using these tactics. The Supreme Court has stated that such an interpretation is in line with the 5-judge bench decision in Sanjay Dutt case, where the Supreme Court has observed that the bail application must be heard forthwith. So students, let us go back and see what we have discussed so far about the remand procedure, what relevance it has in the criminal justice system, when a person can be given for remand, for how many days, what right he has once the period of 90 or 60 days gets over. So as we have seen that initially in the old code, the remand was not given that much importance, but with the introduction of new code of 1973, the remand procedure has been rationalized, not only with terms of the days affording to the investigating agency to complete the investigation, but also by conferring a right to be released on bail on the accused person. As we have seen through a category of cases that even the highest court of this country is favoring the accused person, that once he files a bail application, that is the day on which he is said to have availed of his right to be released on bail, and directed all the courts to follow such instruction. Therefore, we can say that when a person is arrested, he must immediately be brought before the magistrate for further detention. The magistrate must not take it as a routine case and must apply his judicial mind to see whether the case is a fit case for remand or not. And if he finds that the remand is unnecessary or not required or is not justified, he must release that person on bail forthwith. But yes, if it is a fit case for remand, he can use either police custody or judicial custody for that person. As we have also seen that the first 15 days is the only period when police custody can be given. The magistrate is not empowered to give police custody after the first 15 days gets over. With this, I hope that I have cleared some of your doubts with regard to remand procedure under the Code of Criminal Procedure. Have a happy reading and stay touched. Thank you.